Our last case on the docket today is State of Florida versus Dwayne Boatman. Counsel, if you're ready, you may proceed.
May it please the court, Virginia Harris on behalf of the state of Florida. I'd like to reserve 5 minutes for rebuttal. This case involves the state seeking to introduce child hearsay statements. And there was a hearing, and the judge ultimately determined that the child hearsay statements weren't reliable. Now, there's a two-prong analysis for determining that. Only one is in dispute. The first prong deals with the witnesses that testified as to what the child told them. And they appeared live, and the judge found them to be credible, reliable, professional, whatnot. There was no dispute about this. Even defense counsel did not challenge this. The second prong of the analysis has to deal with the reliability of the actual statements by the child, and that's where you look at the time, content, and circumstances of the statement. Now, as you probably already know, I have alleged that numerous errors occurred, so I'll try to go through all of them. The most important ones I'll go into first deal with the fact that the judge appears to have diagnosed the victim with a Sigmund Freud diagnosis of an electric complex. And he did so without any testimony as to this issue in the hearing, and without any notice to the state, which we consider to be highly improper and a denial of due process. The other thing that the judge did is that he considered evidence that was not presented at the hearing.
Counsel, help me with the due process component of that. I think I understand what you're saying there, but would your argument be that by virtue of this coming out of nowhere, no evidence being presented on it, you were never, the state was never given an opportunity to rebut, cross-examine that particular portion of this court's order?
That is correct, Your Honor, and I'm feeling very good about the fact that we could have rebutted that.
And further, in terms of the reliability of the statement itself, was there anything in that statement that would support the trial court's finding of this affinity or electric complex that he said this child had for her stepfather?
Absolutely not, and that kind of delves into the second issue there's so many issues I'm complaining about, but the second one I complain about, the judge used depositions that the prosecutor initially indicated occurred 6 months later, but then later clarified that she thought it was over a year later. And in it, the defense attorney asks the victim, if she loves Mr. Boatman or something to the effect, and that she responds, more than my real daddy. The trial judge puts a parenthetical, because he copies a portion of the deposition, and puts that it's evidence of infatuation, envy of her mother, and KS's emotional problems. So he's now using depositions from 6 months to a year later to find evidence for this diagnosis of his. And it's our position that he shouldn't have been using depositions, period, because they have nothing to do with whether or not the statements that were made 6 months to a year earlier were reliable.
Do you concede there might be circumstances where a statement by a child very close in time to the statement at issue might be relevant to determine whether it was trustworthy or whether the time, content, or circumstances made it reliable?
Absolutely. If it was around the time, because it is the time, content, and circumstances of the statements. So certainly if the child had, right after she reported that, maybe gone back and told a friend, I just made all that up, or something like that, that would be relevant. But not something she says, which ultimately the prosecutor says was a year later. I mean, that, and so we have kind of twofold there. We have the judge considering something he shouldn't be considering, and then also using these statements by the child to support this diagnosis that, as you said, just came out of nowhere. And so the other thing is, The state never presented any evidence about DNA in this case. And the reason why is because the Townsend court, and I have a big Townsend quote in my brief, and this is kind of the last sentence there, indicates that the court is not supposed to consider other corroborating evidence for child hearsay statements. So the state never presented any evidence about the DNA that was found on the child's anus. The judge goes through the discovery and then puts a footnote in his order concocting what he describes as a reasonable hypothesis of innocence for why the DNA was there.
And isn't it clear under the record that even the defendant had not advanced that reasonable hypothesis of
Absolutely
innocence?
not. The only thing the defense attorney advanced was essentially that he did argue the judge should consider the depositions, but only because the victim recanted. But he essentially said she used the word rape, that's a big word, she's now saying she didn't really know what that means, and so now she does, and that was basically his argument. All this stuff about the electrocomplex and this hypothesis of innocence, none of that was advanced. And it's very troubling to me that when you even read this hearing, when you look, not the first couple of witnesses, but when you get to witnesses Palantino, which was the nurse practitioner who examined the victim, and also Christine Bertera, who is the CPT interviewer, the judge is cross-examining these witnesses more than the defense attorney is. And he is obviously doing it in a manner that is hostile to these witnesses. And it's worth noting that the victim never testified live. So it's not as though he had seen her testify and didn't believe her already. The state, during the hearing, introduced the CPT interview, so he didn't see that till afterward, and it appears when you look at the hearing that he was already against the state on this. And I would hope that you would look at the way he questions the witnesses. I mean, he gets on the witnesses about why a 9-year-old child didn't preserve evidence and things like that. I mean, questions you would be expecting a defense attorney to be asking. So it's almost like he departed from his neutral role and took on the role of the defense attorney.
And looking simply at the child protection interview, for instance, and the recording of that, in your brief you argue that our vantage point is equal to the trial courts here in determining whether there is a departure from the essential requirements of law here. Is one of these factual findings, such as the electrocomplex finding by the trial court, is that enough, or are you arguing in the totality?
To be honest with you, I would say that the electrocomplex actually would be enough by itself, but that's not really what I'm arguing. I am really arguing everything, which kind of delves into the next part, the numerous findings by the judge that are not supported by the record, refuted by the record, or his findings actually contradict one another. For example, he writes that witnesses Pickles and Brown, because they testified, that the statements that the child made to them are clearly inconsistent. His example of this, the victim told one of them her stepdad made her have sex with him, and the other one that her stepdad raped her. Well, I don't know about you, but I don't see any inconsistency there. That doesn't make any sense whatsoever.
And wasn't the record clear in her CPT interview? She was questioned about that, and so she understood that rape was to have sex.
Yes, she actually indicates that rape means that he had sex with her. Then she goes on to say that he put his private part in her butt. Then they give her anatomical drawings where she circles his private part as his penis and that the butt is her anus. So she clearly does know what it means. The other thing is that although the judge found that Palantino, that's the nurse practitioner, was credible, reliable, and trustworthy, Palantino had testified that the anus is a very pliable membrane and that there would not be any evidence of injury, bleeding, bruising, something like that. She said she's only seen evidence of that in training and that in real life she's actually never seen it. And she's done 400 to 500 cases. And she says it's because this membrane is so pliable. The judge, after making the finding that she's credible and reliable, then just turns around and says there would be an injury. Now, I understand that you can reject reject an expert's testimony. But if she's credible and reliable and trustworthy, and there's no testimony to the contrary, then what basis is he rejecting her testimony on?
And there was no testimony in this record that there would be an injury?
No, there was no. She said she has never actually seen it in 400 to 500 cases, except in training. And then the judge goes on about the word rape, which is the only thing that is a little unusual in this case. But I'd ask this court to consider that rape is something someone could hear on TV. And the purpose of looking at a child saying a big word is to ascertain if someone is putting words in her mouth, putting her up to this. But the trial court's own findings, which are contradictory, are that either she didn't have a motive to fabricate, even though he then turns around and does this detailed hypothesis of innocence where she's a supervillain and framed her stepfather. None of those involve someone putting her up to it. And so, and looking at the totality of the circumstances, then where else would she get this word? Do you see what I'm saying? I mean, there's nothing to indicate anyone put her up to this, and that's the purpose of looking at a child using a word above her age range, and nobody asks her why.
I'd like to turn you make an argument in your brief that the trial court applied the wrong standard, appearing to apply a judgment of acquittal standard in admitting this evidence, and there certainly is language in the order to suggest that. Even if the facts were supported by CSE, would that be a departure from the essential requirements of law here?
Well, I think what I was trying to say was he's really determining the overall credibility of the child and not the reliability of the hearsay statements. In doing that, so he shouldn't be doing that. That's a JOA argument. Then he also uses the JOA standard improperly. He uses a wholly circumstantial evidence standard. DNA is direct evidence of a sexual battery. So even if this was a JOA, he did that incorrectly also. So, I mean, I see I only have 3 minutes left, so I'll reserve the rest of my time for rebuttal.
Thank you.
May it please the court, I'm Stephen Seliger. On behalf of the Public Defender's Office for the Second Judicial Circuit, we represent Mr. Boatman. I'll try not to ask for rebuttal time. So, I think we need to start at the beginning, which is this is a cert petition. So you have to ask yourself not whether the judge got it legally wrong or he made some factual errors. The question is this an error that is so serious that requires this court's intervention for an issue that the state does not have the right to direct appeal? So my response to everything the state says is the judge did not depart from the essential requirements of law because the judge did what the statute told him to do, which is the state files a notice saying we want to introduce this testimony. The defense objects to the testimony. The judge then decides, okay, the statute says I have to have a hearing. The judge held a hearing. At that hearing, the state got to present every piece of evidence it wanted to present. The judge didn't say, no, you can't call this witness. He followed the dictates of the statute.
Isn't there a fundamental problem when a trial judge is inserting facts in an order that have no basis in the record whatsoever?
If those facts had some, if those facts manifested themselves in the ultimate decision, maybe that's true, Judge Rowe, but not in this case.
Well,
because
if
the
there's
judge,
a collection of them, and we can go through them, I mean, there are at least 10 facts here collectively that are not supported by the record in this order. And given that, doesn't that go to the heart of whether this order was supported by CSE and further, whether there's a departure?
I think you have to ask yourself the question, is there a departure from the essential requirements of law? The judge used the correct legal standard. I haven't heard anything that the judge didn't use the correct legal standard in determining whether to believe the ultimate source of this information, which is the child.
Did he in fact use the correct legal standard?
He did.
He certainly references the judgment of acquittal standard and references reasonable hypotheses of innocence that even the defendant didn't advance.
But the question, Judge Rowe, is ultimately, the judge said, my decision is, and the judge was really clear about that oftentimes, because the prosecutor was arguing you can't consider the later in time evidence about what the child did, and said this never happened. And the judge was really clear. I'm not using it for the purpose of deciding whether to believe the child about whether it happened. I'm using that in the determination of whether her statement is trustworthy. And that's what his job was, because everyone agreed that the messengers of this story were okay. There wasn't an issue with the messengers of the story. The issue was with the source of the story. And that's what the judge repeatedly went back to.
So you would ask this court to look past all of the statements in the trial court's order that are not supported by any CSE, and in some cases not even an argument by the defendant, to look past his statement on the application of the judgment of acquittal standard and the reasonable hypothesis of innocence, and conclude that this judge properly applied the standard for admitting child hearsay evidence.
Yes, because the notion that this judge relied on a judgment of acquittal standard is just a minuscule part of the ultimate decision. He talked about it, but ultimately I think you have to go and ask yourself, did the judge follow the law? And the judge did in this case. And if this was an appeal, then we would be on an abuse of discretion standard. But the cert petition standard is hugely different than whether there was an abuse of discretion about admitting this evidence. This is about, did the judge follow the law? And in this instance, in every respect, the judge followed the law. The statute...
He was following the law when he diagnosed a child with an electrocomplex when no psychological testimony supported that.
The judge hypothesized that. And I'm sorry, but I can't see how that made any difference in whether the judge decided whether this statement that she gave that morning on October the 4th was trustworthy.
If he was considering the time, content, and circumstances, and he believed the child had an inappropriate attraction toward her stepfather, wouldn't that go to the time, content, and circumstances?
I mean, it could, if that was...
And he wrote it in his order.
Well, okay, but he could, but it wasn't the focus of what the judge did. The judge did look at what her statement was. Her statement was, she walks into school one morning and says, my stepfather raped me. That's what she said. She repeated that to two people pretty much off the bat. And then we got these two other people who got involved in more detailed interviews.
I fail to see how these statements are incidental. I mean, it is in the penultimate paragraph before the conclusion that this child may appear to fall under the description of a child with a feminine Oedipal complex, parentheses, electrocomplex. I mean, that's not hard, that's not a footnote on the second page. That's right before the judge reached his ultimate conclusion that this statement was not reliable or trustworthy to be admitted before the jury.
And the judge, in the statement you're reading, Judge Rose, says perhaps. He's speculating.
And isn't that a problem?
It's not a problem because this is not a direct appeal. This is a cert petition. And the judge followed the law. The judge did everything the statute and Townsend required him to do. And when a judge does that at the trial level, an original proceeding in this court is not the remedy.
Is there any, if a judge were to rely on a whole host of facts, does it matter how many facts are unsupported by the evidence or made up before you could overcome this standard, in your view?
If those facts were directly connected to the judge's finding, I mean, it seemed to me it could be one fact if the judge relied wholly on that fact in determining this statement was not reliable. But the judge didn't do that. The judge looked at the time of the statement, that although she walked in and said, my stepfather raped me that morning, what it really turned out to be, she apparently had been doing this for 2 weeks, because the charging document in this case charges 2 weeks. The manner in which she made the statement, the judge repeatedly talks about how people talk about her behavior during the time she was making the statement. She was joking, that she didn't seem to be troubled, all kinds of different observations that the people who were interviewing her made, the use of the word rape, which the child repeatedly used, and the two witnesses by the state explicitly said that is an unusual word for someone who's 9 going on 10. That's not the way 9 or 10-year-olds describe what would happen to them. That's precisely the kind of analysis we tell trial judges to make when they're deciding the trustworthiness of the statement. The judge did that. That's the core order, not this other stuff. That's the core order because that's what goes to him following the law. If he said this statute didn't apply, or that I'm going to ignore the notion that I have to follow Townsend, that would be something different. But I'm sorry, if you're crediting him writing the things that you find troubling, you need to also credit the part that he got right.
Counsel, I
in
don't find them
following the law.
troubling. I find them unsupported by the record
well,
and unargued by the defendant.
Okay, I'm not sure.
That's the distinction. I think that, here you have a trial court order that is based on a whole host of facts that have no basis in the record. And I want to ask you, at what point can there be a departure from the essential requirements of the law? Is it simply enough to parrot the factors and say, these are the factors I apply to determine reliability, and then at the end, I found these factors, and everything in the middle doesn't matter?
Well, that's wrong as a matter of law, because the law is really clear that the judge has to make specific findings. That's the statute says that. So that would be wrong on the law if the judge just parroted those factors. But that's not what the judge did. The judge looked at what people talked about at the hearing and then applied it to the standard, the rule of law that the judge has to follow. And I mean, I kept citing the State versus Smith because I think that's the closest example of when you have a pretrial decision by a judge that appellate judges may decide, if I was a trial judge, I would have ruled the other way. But that's not the way it works. The question is, it's not the application of the facts to the law, it's the application of the correct rule of law. And that's what makes a cert petition a difficult standard to meet. So I'm not sure I answered your question, Judge Rowe, but I'll go back to this. The second part of your question is, I don't care if the defense argued it or not. It's in the final analysis, the statute says the judge has to make that finding. And it's the judge's examination of the evidence that's important, not what the defense may or may not argue. So to me, that's not a pertinent consideration in the decision. I would agree if in this 15-page order, the facts that the judge relied upon were critical to the decision about whether the child's statement was trustworthy over and over and over again. I guess at some point that might reach that standard, although I'm not sure. But I do say if there was one fact that was determinative of the outcome of that trustworthiness decision that was so wrong, that would say the judge didn't follow the law. That would be okay, I think. So I don't think this is a quantity assessment. I think this is, when you read the entire order, not just pick at the details, and that's what an appeal does. You pick at the details. This does not do that.
Well, that's what the judge was doing here. He was picking at the details, and the argument is that picking at details that weren't in evidence.
The judge is allowed to pick at details. That's his job. His job is to look and make decisions about what's credible, what's not credible. So of course he's going to go into the details. It's not the appellate reviewing process that's appropriate to do that. That's what the judge is supposed to do. That's what the statute tells the judge to do. You look at all of these factors, and there's a whole list of them in Townsend and following cases, and even Townsend and all those cases say none of those factors are exclusive. You can come up with any factor that the judge deems appropriate in making this trustworthy finding, because ultimately this hearsay exception implicates serious constitutional issues. So the Florida Supreme Court said, this is a really high standard that you have to meet to demonstrate that this statement is trustworthy. Judge cited all that case law and applied the facts as he understood them to the law. And the important facts which support his following the law are in his order.
What about the argument we just heard, and I think was also in the brief, about the due process violation? You would agree, would you not, that a due process violation below could violate the essential requirements of law, and as that term has been defined in the cases, a miscarriage of justice. So you could have a due process violation that would rise to that level. You would agree with that, would you?
I would
not?
agree with that, Judge Jay.
And so what would you say about the argument that there was a due process violation here with the judge injecting a purported expert opinion that doesn't emanate from the facts? How do you respond to that?
If that was an important fact in the judge's determination, that might be an issue. But at least my view of it is, it's not.
It's not the only important fact that may implicate due process concerns. The other one is his footnote on page 2, footnote 2 on page 13 about the DNA evidence and the theory that was advanced by the trial judge about how the DNA appeared on the child.
Which doesn't matter, Judge Rowe, because this is not, DNA was never talked about at the hearing. It's not critical to whether the statement is trustworthy. What the child did say about the rag where the DNA ended up was she wiped off the front part of her body and not the back, and there was some evidence, and I'm getting all this not from the hearing record, but if you read the record in the discovery part, you could get this. So again, it's just not an important component to the decision of the judge in this case. And I think, Judge Day, a due process violation is not a factual error, ultimately. A due process violation would have been the state saying, we want to set this for a hearing, and the judge saying, no, you don't get a hearing. That's a due process violation. That's the process that a party is due. The state had the process that it was due when it had its hearing. So for those reasons, we would ask this court to deny the cert petition. And as a matter of fact, I would suggest that you decide you shouldn't even have heard this case. Thank you.
We reject the idea that because the trial court just listed the Townsend case, that means that you can't quash his order. I mean, this judge made numerous errors, egregious errors. And in addition to the due process arguments we made, he did violate the essential requirements of law. He violated Townsend and Grego. Grego's the case I cited out of the 2nd District. Townsend indicates that you're supposed to consider the time, content, and circumstances of the child hearsay statements. And this judge heavily relied on depositions taken over a year later for many purposes. And then Grego, the 2nd District case, actually talks about deposition. It says that the trial judge in that case relied on those, and they say, but, you know, we disagree because, one, it would be normal for children to do this, and second, they aren't at issue. In other words, they're saying they're not relevant. And it makes sense, because why would things that a child did about a year later be relevant to whether or not statements are reliable at that time? And so we have that in addition to the due process. I also reject, I mean, I'm nervous based on what I've seen on the case law to ask you to do anything except to just rule on all of the circumstances, because I think that when you rule on all of the circumstances where the judge has engaged in wrongful behavior, that we definitely meet the standard. But I reject the idea that a judge can just cite correct case law and then make numerous findings of fact that are wrong, refuted by the record, and are contradicted by his other findings, and that means that we just can't prosecute someone, because that is what would happen here. In this case, the child has recanted. So he has effectively prevented us from prosecuting Mr. Boatman in a case where we have DNA because she's recanted and we can't use her child hearsay statements. And so I can't imagine that the law is that a judge, and I'm not going to specifically say this judge, but a judge could just completely fabricate findings, and then the defense could get up and say, yeah, but he cited to the correct law. And so that means that there's nothing that you can do about this. This would, as I indicated in my petition, cause irreparable harm to the state. Not just that it would hinder our prosecution, but we may not be able to prosecute him at all. This is one of the most egregious orders I've ever seen since I've been an attorney, and I've been doing criminal law for about 15 years. There's not even a close runner-up. When you look at the case law and the things that trial judges have done wrong, with the exception of maybe Grego, which lists numerous issues where things are wrong, I haven't seen anything on this level. I do want to say, because respondent mentions that, you know, Grego may not still be good law, that there's nothing to indicate it's not. And the second district in a case called Harbison cites to it and actually uses cert petition language and quashes an opinion. It doesn't give facts, but it cites to that opinion, and that case is also in my petition. We ask that you quash the trial court's order. Thank you.
Thank you, counsel. Thank you all. This court will stand in recess.
All rise.